of his profile. Uh, Philip Hackett, Queen's Counsel, is a barrister and a member of the Queen's Counsel. His area of specialization includes financial regulation, health and safety, environment, and consumer law. He has been selected severally as a leading silk by legal directories, including Legal 500 and Chambers Directory. He specializes in financial regulation, civil and criminal fraud, international corruption and sanctions, health and safety, environment and consumer law. His clients are typically multinational corporations, CEOs, finance directors, and other senior officers. He advises on compliance obligations and practice, and at all stages in investigations into potential breaches. For many years, he has been selected as a leading silk by legal directories, including the Legal 500 and Chambers, describing him as an imposing presence in court, a highly articulate and convincing advocate who provides incisive case analysis, and a tactical advocate who is superb at cross-examination and regarded by solicitors as sensitive to the mood of clients. Philip, can you just take us through, what sort of structures were set up in the United Kingdom, for instance, to aid the use of electronic filings? Are there any procedures that have been established? Are you able to file from your office, for instance? Can you take us through that, what the process is in the UK? Thank you.
Well, good afternoon, honourable and learned justices, fellow senior advocates, and distinguished delegates to this webinar. It's a great pleasure to be speaking to you all, especially as I'm doing it from my home in Suffolk in England. Many of you will know me from my work in Nigeria and from lecturing at your many bar conferences. It's very different from doing it from home. When I'm in Lagos or Abuja and I go to speak, I have to ease my way through thousands of delegates, at least 600 of whom would like to take their picture with me. I then move on past hundreds of booksellers, all trying to sell me Professor Susskind's book. I then force my way onto the platform and sit down in front of the microphone to find I'm in the wrong venue. So this life is really, really good, sitting here at home and talking to you. I'm going to just demonstrate that Dapo is right, because I'm going to approach my task like a rhino. And I'm going to behave as if I was in court, because that's really all I know how to do. And what I like to do in court, and I'm going to do with you today, is to tell you my conclusion. I like to start with my conclusion and my final point in court, because I can look at the judge's face and see how much work I have to do. I can hear how much wrestling of papers are going on to my left with my opponent and know if he's concerned. And my point is this, and I'm talking first about civil procedure in England. I'm going to put crime to one side and come back to it later on. I say that everything we need for remote hearings is already present in our existing law and procedure. It's all there. And I can prove I'm right, because between the 26th of March and the 1st of April, so when the shutdown was fully on in London, a 5-day commercial case was heard in full. And in order to achieve that, no changes of legislation were necessary, no new rules, no new guidelines. It was all done by a flexible approach using the existing law and procedure. And I'll say a bit more about that case in due course. The judgment's not out yet, but for those of you who might like to look at it, it's the Bank of Kazakhstan against the Bank of New York Mellon. So you can look out for that judgment. And no doubt the judge may say in that judgment, Mr. Justice Teare, T-E-A-R-E, why he conducted the case in these circumstances completely remotely, every aspect of it. And I should say that one of the parties objected. It wasn't done by mutual agreement between the parties. One objected. And what's more, they were not only doing everything remotely in London, some of the witnesses were giving evidence from other jurisdictions, so they had that additional challenge. So going back to the system that is in place in England, why was that possible? Well, I want to start really with a point that might surprise you. I want to say the key thing about our system for electronic working and remote hearings is that our sanctions regime in our commercial court, our chancery division, is very, very strong. And if you don't meet one of the court orders and you don't meet one of the deadlines, you have a problem, because sanctions are automatic and the party who is in breach has to apply for relief from sanctions. And a typical sanction would be in costs, so your client gets hit in the pocket for the delay or the failure to comply with an order. You must have a sanctions regime if an electronic working regime is going to have effect. And I mean, there are terrible delays in the courts in England, and I've done cases in Lagos, and I know there are delays there. But the difference was that in England, the parties were penalised, and when I've been in cases in Lagos and there's been delays, the penalties weren't there, they weren't imposed. I've even been with a very learned SAN at court in Lagos, waiting for the other side to turn up, and they didn't turn up. They rang the judge's clerk and said they weren't coming. And I'd flown all the way from London to watch the case. And there were no penalties imposed. The judge expressed his displeasure, and it all went off. As far as I'm concerned, I don't think the case was ever heard, actually. So sanctions are vital. So what is the system? Now, I'm obviously not, in my 10 minutes, going to have time to go through it. I'm going to give you some references, if I may. This is all on the internet if you want to look further and follow it up. Our civil procedure rules are on the internet. Civil procedure rules part 5 deals with electronic working. Practice directions 5A and 5B deals and filing. Now, that's been in place for many years. We're all used to how it works. You'll find there are provisions there for sending material to the court by email, for instance, and what the rules are. The only time you can't lodge a document electronically is if it's a document for which a fee has to be paid. So that typically would be issuing the proceedings in the first place. But when you get beyond that and you get to the full statement of claim, you get to skeleton arguments, bundles of exhibits, that sort of thing, it all can be done electronically. So that's the foundation that enables us to move towards remote working. Further guidance, if anyone wanted to see how this could be done and argue for a development in Nigeria or anywhere else, we have commercial court guides and chancery division guides, and all the divisions of the High Court have their own guides. And you will find, and they're all available online, you will find there further elucidation of the rules as to what's required for electronic working. Now, none of that has anything to do with the current crisis or the Coronavirus Act 2020, which has been passed. Now, what about witnesses remotely? Well, again, you can get this online. If you look at Civil Procedure Rule 32 and Practice Direction 32 Annex 3, you'll see the rules for video links. And this has happened for years and years and years. There's nothing new about it. There are complications, of course, particularly if you're taking video evidence from a foreign jurisdiction, because there may be matters of legal and political comity, there may be mutual legal assistance rules that require you to behave in a certain way in that foreign jurisdiction. Quite often you might need permission from the foreign judicial authorities you might have to take the evidence in a formal setting in a court. But if you look at those rules, they've always provided tremendous discretion for the English judge in how he conducts it, for instance, how he takes the oath or how he gets the affirmation. So all the kit was already there. It's just that our mindset was that you couldn't conduct a case completely remotely. Why? Because we're steeped in the common law tradition of testing the evidence, of cross-examination, and we just hadn't conceived that it was possible. Well, it's just been done in the High Court in London. We can look out for that judgment when it comes. And I'll give you a couple of other examples. I noted this week there were 2 defamation cases where the judge, Mr. Justice Nicklin, who's the specialist liable judge, had given 2 important rulings purely on written submissions. And because of that, he attached the written skeleton arguments to the judgment. So there's your public access to justice aspect of it, and we can all go and copy those skeleton arguments when we want to. Anyway, the judgment doesn't say if the parties agreed or objected or how he came to that conclusion. One of the cases, I'll give you the name, Riley, R-I-L-E-Y, against Murray, M-U-R-R-A-Y. It's particularly interesting. I'm going a bit off piste here, but I always do, because it's about Twitter. And Riley is a TV personality, and Murray said something rude on Twitter about Riley. And the case, you know how Twitter works. You put something on Twitter and every lunatic in the world logs onto it and says something else. And the question was, is the original author of the original tweet to be considered in the context of everything that followed? So it's a very good case. I commend it to you. So that's how things are developing here in London. A further really important development was there used to be a rule against broadcasting and photographing what went on in court. That was so strict, people used to get sent to prison. It was quite recently, get sent to prison. They've now made provision whereby the proceedings, such as they are, can be broadcast on YouTube, and the documents can be made available on YouTube. So this is a tremendous shift in thinking. So there is a big issue about the platform. Now, I'm not a technology expert, but in Mr. Justice Tier's judgment, when it comes out, he'll explain that they used Zoom, as we're using today. Now, Zoom has been criticised over security, but this High Court trial was connected via Zoom. I just want to say one thing about that trial. The issue was pretty technical. The issue was whether the £530 million being held by the New York Bank of Mellon was subject to a garnishee order in order to enforce an arbitral award. And what they had was 1 witness of fact and 4 expert witnesses. So that doesn't sound that contentious. It sounds rather technical, doesn't it? So I think that may be why it was susceptible to this revolutionary approach using the existing rules. The barrister who conducted that has done a webinar, as you'd expect, and he said there were no problems. Possibly not in that court, but I'm going to beg to differ. And I'm going to shift now to criminal proceedings. Now, we've had the video hearings for years and years and years, and it's a fantastic thing that everyone likes, whereby people who are in prison don't have to be brought to court for short hearings. Lawyers don't have to go to court for short hearings. The judge can agree that he will use the court video system, and in prison, the prisoner goes to a video room, the barristers go to their local court and to a video room. Now, that's all going to have to be expanded so we can do it from remote locations, but it's been a tremendous facility, and everybody's in favour of it. But we've also had video link for witnesses for a long time. And just this afternoon, in preparing this, I remembered that one does forget things when you've been practicing as long as I have. I remembered that about 7 or 8 years ago, I did a really controversial case where the principal defendant was from Cyprus and he was in London on trial, and we had witnesses in Cyprus who wouldn't come to London for all sorts of good reasons, but they were on both sides of the peace line there. You will recall Cyprus is divided after a really controversial civil war. And we had these witnesses coming to the witness box, and it was being done in all sorts of locations, and arguing and shouting and being rude to the judge, and nothing could control them at all. So although this technical commercial case went well, I personally have been in a case where the witnesses were foreign witnesses by video link, and it did not go well at all. So that's my answer to the first question. I'll just try and win the point, which I said I would win by showing there has been a trial under the existing rules, by telling you that the Coronavirus Act 2020, which makes provision for criminal cases, has no provisions at all for civil cases. So everything that judge has just done in London, having a completely remote trial, has been done under those existing rules that I spoke about.
Thank you very much. Thank you, Philip.